have no computer connection to my computer. None at all.
If you signed in to Stevens when you signed in.
Excuse me one moment, Mr. Crosland. Yes, Mr. Crosland.
Good morning, my ladies and my lords. Thank you for your time today and for your time in preparing for the hearing. I appear on my own behalf as an appellant in person. Mr. Aidan Eardley appears as counsel for the respondent, the Attorney General. Normally it's the appellant who prepares the bundles for the court. I must thank the Government Legal Department for their substantial cooperation. In that regard, they took the lead in preparation of the authorities bundle and the very substantial tasks of cross-referencing the bundles and printing the bundles. This appeal arises out of my decision on the 15th of December 2020 to break the embargo on the draft judgment of the Supreme Court in support of the expansion of Heathrow Airport, some 22 hours before it was due to be handed down.
Yes, now, Mr. Crosland, we obviously read the written materials which you've very helpfully prepared, and in particular your full case, and we've read the attorney's materials as well. You appreciate we're under quite a tight timetable. Now, there is, of course, a challenge to our jurisdiction to hear this appeal from the attorney. What we propose to do, subject to anything you want to say, is to hear your full appeal without deciding at this stage the question of jurisdiction, which on the attorney's written case might confine us to considering only some of your grounds of appeal. We will then consider all the matters, your grounds of appeal and the question of jurisdiction, so that we can give a single judgment at the end of the day. In lawyers' language, we will therefore hear it all de bene esse, which I'm sure you understand, which is a summary of what I've just said. So if you'd like to go, we will ask you to go first, of course. Anything you want to say about jurisdiction, by all means, include within your submissions, or you can wait to see what the attorney says and say something about them in a brief reply. And we're entirely content that you take your own course in relation to that. And indeed, you can do it at any stage in your submissions. You don't have to do it up front.
My Lord, in some ways, it is an issue that comes first. It feels like a preliminary issue. My submissions on...
Well, we could have dealt with it that way, but we've decided to do it all in one go.
In that case, my ladies, my lords, may I take the jurisdictional point first?
Certainly.
I will be very brief on that. The starting point is the order of the Court of First Instance. That's the Court Bundle, tab 7, page 123. And the order of that court, if permission to appeal against the finding of contempt, the penalty imposed and the order for costs is required, the respondent is granted permission to appeal to a differently constituted panel of the Supreme Court. Next, if we turn to Court Bundle... Just a minute,
Mr. Crosland. If you can possibly give us the electronic page numbers, it would help. But if you're don't worry if not.
I have those as well.
They're only about 3 pages out.
So this is electronic bundle, page 17.
Thank you.
The Attorney General's notice of objection.
Yes.
And you'll see no permission is sought to cross-appeal the court's order of the 10th of May, which means, in my submission, this issue is not properly before the court. In any event, the Attorney General's position is logically difficult. He seeks to reverse the order of the Court of First Instance by arguing that there is no appeal against the order of First Instance. And if this court has no jurisdiction to reverse an order of the First Instance Court, it has no jurisdiction to vary paragraph 5 of the order which grants me a right of appeal. There are 2 clear bases for the court's jurisdiction to hear this appeal. The first is the Administration of Justice Act 1960. That's page 952 of the electronic bundle. that says in clear terms, subject to the provisions of this section, an appeal shall lie under this section from any order or decision of a court in the exercise of jurisdiction to punish for contempt of court, including criminal contempt. And in relation to any such order or decision, the provisions of this section shall have effect in substitution for any other enactment relating to appeals in civil or criminal proceedings. My ladies, my lords, that is clear, express statutory language. There is a right of appeal in relation to any decision concerning contempt of court. It is perfectly correct. The statute itself doesn't directly address how that will manifest itself, where the Supreme Court has been the court of first instance. That is an unusual situation, and that has been left to the inherent jurisdiction of this court. Second, this court, in accordance with the principle recognised by the House of Lords in the Pinochet case, that's page 773 of the electronic bundle, has the inherent right to vary or rescind any previous order it has made. The words of Lord Brown-Wilkinson, as I have said, the respondents to the petition do not dispute that your lordships have jurisdiction in appropriate cases to rescind or vary an earlier order of this House. In my judgment, that concession was rightly made, both in principle and on authority. In principle, it must be that your lordships, as the ultimate court of appeal, have power to correct any injustice caused by an earlier order of the House. It's perfectly correct to say that Lord Brown-Wilkinson goes on to say the House will not reopen any appeal, save in circumstances where, through no fault of the party, has been subjected to an unfair procedure. There are 2 points to make about that. First, it does not apply to this situation because no one has asked this court to reopen an appeal. In this case, this is the first appeal from the court's judgment of first instance. And secondly, this appeal does concern the fairness of the appeal process, in particular the allegation that the court below was neither fair nor impartial, as in the Pinochet case. So those are my submissions on jurisdiction.
Do you take a point about this court not being able to hear an appeal, in the sense of you take a point about the court of first instance being conflicted? Do you take the point about this court, this panel?
My lady, that's in some ways. My point on bias was twofold, and we'll come to this later. Firstly, that it was this court that made the complaint to the Attorney General, and it was this court that made a complaint about me to the Bar Standards Board. And secondly, that my justification for breaching the embargo involves the claim that the government's error, fundamental and terrible error in relation to the Heathrow approval process of using the wrong climate target, the 2-degree target, not the 1.5-degree target, that was whitewashed away in the judgment of the Supreme Court on the Heathrow appeal, and it would therefore be very difficult for this court to be truly neutral about that issue. Well, my lady, logically, those points still have force in this situation.
Too.
That is, logically, that is correct.
Court, and you're saying, well, this court was acting as, in effect, initiating the proceedings for contempt.
Indeed.
So this panel too is one which is conflicted.
It's hard to escape the logic of
yes, I understand
that.
But I want to be clear as to what your
But
position
yes,
is.
indeed, that is correct. It's a different situation this panel finds itself in, because in this case I'm not inviting the panel to find that there was suppression of evidence. The role of this panel, as I see it, is just to consider whether that allegation was dealt with appropriately by the court below. The key legal issue being the issue in the case of Ziegler, in a case which engages Article 10 of the European Convention, are the motives, beliefs, and intentions of the person exercising that right relevant or not? The court in Ziegler said they were. The court below and the Attorney General said they were not. That is the key legal point. So I do submit there's a distinction between the position this court finds itself in and the court of first instance, but nevertheless, those points still have some force.
Thank you.
Working with the judgment in Ziegler, the point is the factual context is part of the matrix of assessing proportionality under Article 10. So before getting into the legal grounds, just set a little bit more of that factual context out. I took the decision to break the embargo, conscious that the consequences for me personally were likely to be serious. They might include a sentence of imprisonment. They might include being struck off as a barrister. Certainly, I did not envisage any personal benefit arising from that action. And in the event, following a referral from Lord Reid, that's where we end up here. There's a prosecution for contempt of court, and there's the referral to the Bar Council. As I understand it, there's also a complaint to the Charity Commission not made by this court. The hearing takes place on 10th of May this year before Lord Lloyd-Jones, Lord Hamblin, Lord Stevens. Contempt is found proved, fined £5,000, and ultimately some 6 weeks later, ordered to pay £15,000 costs, a combined financial penalty of £20,000. Court granted me permission to appeal, and given the constraints of time today, I will focus my submission on just 3 of the 5 grounds of appeal, which I summarise as follows. First, ground 1, contrary to this court's recent ruling in the case of Ziegler and others concerning the proportionality of any interference with the right to freedom of expression, the court of first instance wrongly disregarded my intentions, motivations and beliefs, and in particular the substance of my defence, which was that the evidence that Heathrow expansion would cause the 1.5 degree goal in the Paris Agreement to be breached, with devastating consequences for the public, had been wrongly concealed from the public. First by the Right Honourable Mr. Grayling, the Secretary of State for Transport at the time, and then by the Supreme Court itself. Second, which is my third ground of appeal, contrary to the common law principle that no one should be a judge in their own cause, and contrary to the European Convention Article 6, the Court of First Instance was not an independent and impartial tribunal. And third, that the ruling of the court on costs, which was 3 times greater than the fine, was arbitrary and unjust and wrongly disregarded the legal principles applicable to costs orders in criminal proceedings, in particular the principle that the costs ought not to exceed the fine. Before turning to those grounds in more detail, I will address directly the question put to me in the court below. What purpose did it serve to break the embargo when the judgment would in any event be published the next day? There would be plenty of opportunity to scrutinise the court's analysis once it was made public. My ladies, my lords, that point would have force if my objection were to the legal analysis of the Supreme Court, which would soon have been out there for all to see. This is not an attempt to rehear the legal analysis of the court below. That was not my objection. My objection was to the factual matters which had been suppressed from the judgment, and which would, for that very reason, not have been visible to the public on publication of the judgment. More specifically, my objection was that the judgment served to conceal the government's extraordinary and deadly error, that Mr Grayling had assured the public that Heathrow expansion was consistent with the UK's international obligations on climate change, but that was only because he had used the wrong measure, the historic and discredited 2-degree target, which had been rejected by the international community in 2015 as exposing humanity to intolerable risk. Had he used the correct global limit, the 1.5-degree Paris limit, he would have been bound to inform the public that expansion was inconsistent with the UK's international obligations on climate change, because according to the government's own figures, expansion implied 40 million tonnes a year of carbon dioxide emissions just from UK aviation by 2050, whereas the 1.5-degree limit demanded global decarbonisation by 2050. Had Mr Grayling provided accurate information, the public would then have understood there was a clear choice to be made between aviation expansion or conserving the conditions which make the planet habitable. It was one or the other, not have cake and eat it. The consequences of breaching the 1.5-degree limit, according to the peer-reviewed science, are devastating. My ladies, my lords will have seen for themselves, I hope not directly, but at least indirectly, the impacts of the current level of warming, just 1.2 degrees over the summer. The rows of prostrate people in cooling centres in Canada and North America, the heat dome. Whole villages devastated by floods in Germany and France, infernos around the Mediterranean, the flooding in London and around the UK, the devastating impacts of climate change which have been commonplace in the global south, out of sight, already for far too long. The science predicts that if the 1.5-degree threshold is crossed, whole regions of the world will be left uninhabitable as the wet bulb temperature passes 35 degrees Celsius, beyond the capacity of the human body to cool itself down. And the risks of multiple simultaneous breadbasket failures rise substantially, risking famine. Mr Grayling's reliance upon the wrong climate target...
Mr Crosland, if I can assist, I don't think the panel before you today is in any doubt as to what your intentions, motivations and belief were. I think we will be more assisted by you developing your case under this ground of appeal that the panel of this court which found you in contempt ignored them, contrary to Ziegler. You can assume that we understand the principles laid down in Ziegler, but we need to see the nitty-gritty, if you don't mind, of how you say that the panel which acted at first instance ignored them.
Okay, of course.
I'm
Just
not belittling,
a very brief preliminary point.
Say, nor am I in any way belittling the matters which you're referring to, but I am conscious of the time and your need to focus on the submissions that you've so far dealt with very succinctly.
Thank you, my lord. So I move on to, should we get straight to that point?
Yes, please, absolutely. We have, of course, read the judgment given by the panel sitting in first instance, but by all means take us to passages there if they make your point.
Of course. So turn to key documents bundle. This is EF, so electronic bundle, page 12.
Yeah.
This is the statement of facts and issues agreed with the Attorney General. So this is...
I have it on another page.
It's 154, I think.
KD...
In the key documents bundle, it's EF 154.
So it's page 10 of the key documents bundle, and EF page 162.
Thank you.
Sorry. And see at paragraph 22, the appellant wrote to the government legal department inviting the respondent to ask the Supreme Court various questions as part of its investigations, including the following, and Roman 1. Is it correct that the Secretary of State assessed the airport's national policy statement against the historic temperature limit of 2 degrees as opposed to the Paris temperature limit of 1.5 degrees? Roman 2. Was it central to Plan B's case that the Secretary of State should have relied on the Paris temperature limit instead of the 2-degree limit? Roman 5. Why did the Supreme Court's draft judgment make no reference to the Secretary of State's reliance on the 2-degree limit? And you will see paragraph 23, this is now electronic bundle page 163, the Attorney General's office neither responded nor pursued these lines of inquiry as it considered them irrelevant to the question of whether the appellant committed contempt of court. Next, if we go to the transcript of the hearing in the court below, that's appendix tab 23, electronic bundle, page 570. And on the transcript, it's the little page 10. You get sort of 4 pages of the transcript on each page, line 7. And the Attorney General's position: it is not necessary, we say, for the court to take into account Mr. Crosland's motives for acting as he did, or the beliefs that led him to do so. Line 15. On the question of liability, we say motives and reasons for acting don't come into it. The approach adopted by the Court of First Instance conforms to the Attorney General's analysis. This is electronic bundle, page 247. The judgment of the Court of First Instance. And at paragraph 16, you'll see the principal issues as set out by the court. These were the same issues that the Attorney General had advanced, and it was a bare analysis of whether the elements of contempt of court had been made out. There is no space in that analysis for an assessment of my motivations, intentions, and beliefs. In other words, the court fundamentally failed to conduct the balancing exercise required by this court in Ziegler. It made that clear at electronic bundle, page 251. This is paragraph 29 of the judgment of the court. The respondent submits that the court should have regard to his intentions, beliefs, and motivations in disclosing the result of the appeal. He submits that he was justified in doing so in breach of the order because this was a reasonable and proportionate measure to prevent harm to the public as a result of the catastrophe which he believes would be caused by global warming. To that end, he has placed before this court material which we have read relating to what he sees as the erroneous approach of the Supreme Court and the consequences to which it will lead. Paragraph 30. In our view, these matters do not assist the respondent in relation to the issue whether there has been a contempt of court. And then paragraph 33, you see that same approach articulated again. Thirdly, the respondent submits he cannot have had the requisite mens rea to be in contempt of court because he was acting for the purpose of preventing serious harm to the public. There is, however, no defence available to the respondent arising out of his concerns or fears as to the consequences of the Supreme Court's decision. There is here no defence of public interest. There is no such thing as a justifiable contempt of court. And my ladies, my lords, I say that analysis is the wrong way round. The analysis required by the court in Ziegler is that in order to determine whether there has been a contempt of court, it's necessary to consider the balance, proportionality, and that includes the intentions, motivations and beliefs of the person exercising their right to freedom of expression under Article 10. It's difficult to prove a negative. There's no particular point in the judgment that one can refer to, but it is also a fact that my ladies, my lords can reassure themselves of in their own way. There is no mention anywhere in the judgment of the court below that my defence was that evidence had been suppressed. That just does not feature, although that was the central part of my case. And just to illustrate that, goes to page 570. My opening words to the Court of First Instance, this is the little page 11 of the transcript. My lords, I broke the embargo on the Heathrow judgment because I believed that, 1, the evidence that Heathrow expansion would breach the Paris temperature limit of 1.5 degrees, exposing the public to extreme danger, was being deliberately suppressed from the public domain to smooth the progress of the £14 billion project. And that 2, the antidote to that suppression was the spotlight of publicity that would follow from breaking the embargo. My ladies and my lords, I could not have put it more clearly that that was the basis of my action. That isn't even mentioned in the judgment of the court below.
Do you want to say anything about paragraphs 39 to 41 of the first instance judgment, which starts at electronic page 252, page 100 if you're using paper?
It's the judgment, not the transcript. Is that?
No, it's the judgment. It's the section that's headed Article 10 ECHR. I don't feel you have to, but it's an opportunity. It's a convenient point to do so if you want to.
So. My ladies, my lords, yes, indeed. This shows that the court below, on the one hand, recognised that this was a case which engaged Article 10, and it shows the narrowness of their approach. They simply do not follow the approach of this court in Ziegler. The only question they ask themselves is whether paragraph 40, a permissible interference with freedom of expression must therefore be prescribed by law, must pursue one or more of the legitimate objectives in Article 10.2, must be necessary in a democratic society for the achievement of that aim. In the present case, the prohibition on publication of the judgment of the Supreme Court prior to hand-down did amount to a restriction on the disclosure of information. However, and this is the last bit of paragraph 41, the restriction was clearly necessary in order to achieve the legitimate objective of maintaining the authority of the judiciary and judicial decisions, and was a proportionate means of achieving that result. So, my lord, thank you. Yes, that indeed is where the contrast between the decision of the court below and the court in Ziegler is most stark. It is precisely the same question they're addressing, and they adopt a fundamentally different approach.
Thank you.
So in my submission, were this court today to uphold the judgment of the Supreme Court, it would be a coach and horses through this court's judgment in Ziegler, and would leave the public in a confusing position at a time when the right to protest, the limitations around that right, are a matter of profound public concern, one of the dominant issues of the day. And in my submission, this court should be very slow to do that, the court in Ziegler had the opportunity to go through the jurisprudence, both the common law jurisprudence, the Strasbourg jurisprudence in considerable depth. But because that, in my submission, is what is in issue today, I would like to refer the court to relevant passages of the case law, just remind this court why it came to the decision it did in Ziegler.
But just before you do, I wonder if you could help me. I've made careful note of what your case was on the transcript. But could you just help me on this? Why did you have to reveal it before hand down? Why couldn't you deal with it after hand down? Because it might be said against you, and I think it is said against you, that there was a restriction here, and it wasn't one you had to break. You took a decision deliberately to break it.
Lady, I understand that is the point, that is the question, and that relates, in my submission, to the reality of the situation. It would have been far, far easier for me personally to wait and to make my point afterwards. I wanted to believe I could do the same thing afterwards because that would have been so much easier. But I knew it wasn't true. I knew if I'd waited for the judgment to come out and I'd then said, oh, well, the court's made a mess of the facts and it hasn't mentioned the government's use of the wrong climate target, with the news cycle as it is, wouldn't have been mentioned. I'd tried highlighting that point previously because the government's error had come out in January 2019 following disclosure of the witness statements, and it was just too technical to get anybody's interest.
But it wouldn't have conflicted with your right to freedom of expression, would it? To have to make your comments after hand down, when everyone else had seen it?
The right to freedom of expression for an ordinary individual who's up against the power of large PR departments, companies like Heathrow Airport Limited, one of the largest companies in the country, the power of the government over the media, there's some inequality of arms around that. So my assessment was that the stakes here were so high, the consequence of that error was so terrible, the obligation was to do everything that a person in my position could do as a volunteer for a small charity to get that information out loud into the public, and that, in the nature of things, required something more dramatic than a disappointed litigant complaining about facts being omitted from the judgment. And the proof, I say, is in the pudding. The reality was that within half an hour of sending out my message, which was just to the outcome, so it was a proportionate breach, it wasn't harming anybody, it didn't interfere with anybody's privacy rights, within half an hour, I have pretty much all the national media outlets on the phone, from the Daily Mail to the Financial Times. Why have you done what you've done? And through that act of protest, it's inherent in acts of protest. You disrupt things in order to gain attention in the way ordinary people can. Through that, I succeeded in getting that information into the public domain. My reasons for doing what I did were widely reported in the national and international press. It was as a result of that more than 100 leading experts, climate scientists such as Sir David King, government's former chief scientific advisor, Professor Jeffrey Sachs, special advisor to the UN Secretary General formerly, and many, many others, they then take the initiative to write to the Supreme Court and express concern about the judgment. People from all over the world. In my submission, that just would not have happened if I had waited for the judgment to be published. It's just the reality.
Thank you. Now, does that conclude what you want to say about your first ground?
So the only other point was to take the court to the case law on that point.
Yes, well, you could do that quite briefly, because I think you can take it that
My Lord,
we are
first,
reasonably familiar and will study the case law after the hearing.
of course.
Rather than read it out, probably the best thing to do is to give us the references that you'd like us to study.
Certainly. Just a handful of key passages,
Okay.
if I may.
Yes?
Most directly relevant, the dicta of Lord Bingham in the case of Shayler. This is the Authorities Bundle, Volume 1, Tab 8, page 210, and it's at Section 21D.
We've got the electronic page for us.
Of course. So, 869.
Thank you very much.
And I'll just read out this passage because it is so strikingly in accordance with my motivation. The reasons why the right to free expression is regarded as fundamental are familiar, but merit brief restatement in the present context. Modern democratic government means government of the people, by the people, for the people. But there can be no government by the people if they are ignorant of the issues to be resolved, the arguments for and against different solutions, and the facts underlying those arguments. The business of government is not an activity about which only those professionally engaged are entitled to receive information and express opinions. It is, or should be, a participatory process. But there can be no assurance that government is carried out for the people unless the facts are made known, the issues publicly ventilated. Sometimes, inevitably, those involved in the conduct of government, as in any other walk of life, are guilty of error, incompetence, misbehaviour, dereliction of duty, even dishonesty and malpractice. Those concerned may very strongly wish that the facts relating to such matters are not made public. Publicity may reflect discredit on them or their predecessors. It may embarrass the authorities. It may impede the process of administration. Experience, however, shows in this country and elsewhere that publicity is a powerful disinfectant. Where abuses are exposed, they can be remedied. Even where abuses have already been remedied, the public may be entitled to know that they occurred. The role of the press in exposing abuses and miscarriages of justice has been a potent and honourable one, but the press cannot expose that of which it is denied knowledge.
Thank you.
I may now turn to this court's judgment in Ziegler.
Yeah.
This is tab 2 of the first authorities bundle. And page 692
Thank you.
of the electronic bundle. Paragraph 59, and I won't irritate the court by reading everything out, so it's that paragraph there about the relevance of the factual context.
Sorry, which paragraph?
Paragraph 59.
Thank you.
So this is the judgment of Lords Hamblin and Stevens. And requires the evaluation of circumstances in the individual case. And then following a review of the Strasbourg authorities, at paragraph 70 of the judgment, which is 696 of the electronic bundle. Again, I won't read the paragraph out, but if the court would like to read paragraph 70.
Thank you.
And in fact, 71 as well. And then paragraph 72, I'm just going to highlight a key part there because it's right on point. Paragraphs, and this is a reference to the City of London versus Sammead case, the Occupy London case, paragraphs 40 to 41, Lord Neuberger identified two further factors as being A, whether the views giving rise to the protest relate to very important issues, and whether they are views which many would see as being of considerable breadth, depth and relevance. And B, whether the protesters believed in the views they were expressing. In relation to B, it is hard to conceive of any situation in which it would be proportionate for protesters to interfere with the rights of others based on views in which the protesters did not believe. That's directly in opposition to what the court below concluded. Paragraph 77.
I'm sorry, you said directly contrary to what the court below concluded.
As in that my intentions, beliefs and motivations were irrelevant to the question of whether there had been a contempt of court, even though they acknowledged that Article 10 was engaged.
Yep.
And at paragraph 77, you will see, this is actually the last sentence of that paragraph. While there is autonomy to choose the manner and form of a protest, an evaluation of proportionality will include the nature and extent of actual and potential breaches of domestic law. In other words, it's not enough to be able to say there is a bare breach. The extent of the breach of the law must be considered, where Articles 10 and 11 are engaged. And my Lady Arden then emphasises the same point at paragraph 92. That's page 704 of the electronic bundle. She says, previously it was, for instance, no excuse that the obstruction occurred because the defendant was giving a speech. Sorry, did I say this is paragraph 92?
Yes.
The Human Rights Act has had a substantial effect on public order offences and made it important not to approach them with any preconception as to what is or is not lawful. As Lord Bingham observed in Laporte, the Human Rights Act, giving domestic effect to Articles 10 and 11 of the European Convention, represented a constitutional shift. And then at paragraph 97, my Lady Arden quotes the Strasbourg judgment in Navilyi v. Russia, which concerns directly Article 10 but applies equally to cases engaging it concerns Article 11, but equally applies to Article 10. It was all the more important to adopt measures based on the degree of disturbance caused by the impugned conduct and not on formal grounds. Now turn to directly to the case of City of London versus Sammead, the Occupy case, which was referred to in Siegler.
Explore this, Mr. Crosland, that these cases are Article 10 cases, except for this one you've referred us to, which is Article 11. But is there something special about freedom of expression in Article 10 cases that raise this issue of the need to consider the alleged contemner's beliefs and intentions? There are many cases in which a litigant, on seeing the draft judgment under embargo, is very upset that facts have been found against them and believes that the court has completely got the wrong end of the stick or has had the wool pulled over its eyes by the opposing side. And as a judge, you see many very heartfelt protests of that nature. Now, in those cases, is there a balancing act if that litigant decides this is a really important issue and I'm going to disclose this judgment before the embargo, before hand down? Can they mount the same sort of argument as you're mounting, that they genuinely strongly believe that there has been a miscarriage of justice in their case? I mean, or is there something special about your case?
My lady, in the ordinary case, I would have thought the answer to that is going to be no. Certainly the Article 10 right doesn't simply protect a disappointed litigant in expressing a general feeling that the court has reached the wrong verdict. And so even if technically it engages Article 10 because it's an act of freedom of expression, in the vast majority of cases, the balance in my submission would come down very clearly against the person breaching the embargo. What distinguishes this case, in my submission, is the allegation that matters of urgent public concern had been concealed. The use by the government of the wrong target. And that is a matter which the Attorney General now accepts. I mean, it's there in the statements of facts and issues, accepted by the government now, that the Attorney General, I beg your pardon, the Secretary of State for Transport used the 2-degree target, not the Paris target, to determine his approval for Heathrow expansion. That is now a fact. And so that would not be found, that feature, in the ordinary case where a factual matter of extreme public concern concerning conserving the conditions on which the habitability of the planet depends has been concealed from public view. It is also a matter of record. The government told the public this is consistent with our international obligations on climate change. It was not true. And so I don't believe that factor would be there in the vast majority of cases.
Thank you. I'm slightly probably more conscious of the time than you are, Mr. Crosland, because I can see the clock. You've got 2 more main headings to deal with. I appreciate that this first one is the one upon which you place the most emphasis.
It is indeed. So, well, I will speed up. Just one last judgment,
okay.
Which is judgment of the European Court of Human Rights in Moore versus France. That's electronic bundle 903. The judgment itself is not available in English. What you have in the authorities bundle is the court's own English language case note. It relates to a lawyer who spoke to the press about a confidential expert report prepared for the court in breach of her obligations to the court relating to important matters of public health. The domestic court in France found her guilty of breach of professional confidence and ordered her to pay €1, a token fine. The European Court held that even that was a violation of the lawyer's Article 10 right. And I'll just read out the key passages here very briefly. The applicant's comments had formed part of a debate of general interest. The facts have been of direct relevance to a public health issue and had concerned the liability of pharmaceutical laboratories and representatives of the state. The issue had therefore been of undoubted interest to the general public. In that connection, there was little scope under Article 10.2 for restrictions on debate on questions of public interest. The disclosure of information to the media was apt to safeguard the public's right to be informed of the activities of the judicial authorities. Accordingly, the need to protect confidential information did not constitute sufficient grounds for finding the applicant guilty of breach of professional confidence. The protection of that freedom had to take account of the provision made for exceptional cases, which I say this is, in which the exercise of the rights of the defence make a breach of professional confidence necessary. In my submission, there's no reason to doubt the Strasbourg Court would come to precisely the same conclusion in this case. since the government's error regarding Heathrow expansion was a matter of such vital public concern.
Doesn't it come back to my question? This is a case, presumably, where the confidential information was not ordinarily to be released. But in this case, the restriction on confidence ended on the Monday morning when the judgment was handed down. So the points were open to you at that stage.
My lady, that point, I mean, it cuts both ways. Because on the one hand, if one's putting into the public domain something that is not otherwise going to come out, the person who does that is taking responsibility for all kinds of questions, potentially engaging privacy, the potential violation of other people's rights are more extreme. In this case, what was coming into the public domain was going to be there anyway, so there was no violation of anybody's privacy. So that's one aspect of it. But it was only by breaching the embargo that I was able to get the spotlight of press attention on this error. It is as simple as that. So it's in terms of my objective, which was to get the truth out there, this proved to be effective. That information is now out there. It is now understood. I didn't believe that would happen if I waited. The news cycle would move on too fast.
Thank you.
Those are my submissions on ground one.
Thank you.
Turn now to ground three. There's some intersection with the two things. The principles concerning bias are both well known, fundamental to the common law. Turn to authorities bundle, tab 6. This is the Pinochet judgment, electronic page 773. Lord Brown-Wilkinson sets out the general principles. Fundamental principle is that a man may not be a judge in his own cause. Electronic bundle, maybe I can just say the page and you know it's electronic. 776. If the absolute rule of the impartiality of the judiciary is to be maintained, there must be an absolute rule which automatically disqualifies a judge who is involved, whether personally or as a director of a company, in promoting the same causes in the same organisation as is a party to the suit. There is no room for distinctions if Lord Hewitt's famous dictum is to be observed. It is of fundamental importance that justice should not only be done, but should manifestly and undoubtedly be seen to be done. And then electronic page 781, around paragraph F, Lord Hope quotes from Seller and Highland Railway. The importance of preserving the administration of justice from anything which can even by remote imagination infer a bias or interest in the judge upon whom falls the solemn duty of interpreting the law is so grave that any small inconvenience in its preservation may be cheerfully endured. Page 782, paragraph C to D, Lord Hope says directly, it is only in the most unusual circumstances a judge sitting in criminal proceedings would find himself open to the objection he was acting as a judge in his own cause. In practice, judges are well aware they should not sit in a case where they have even the slightest personal interest. And then that principle is given slightly new expression in La Voile, the Northern Spirit. That's electronic page 741. Page 750, the principle to be applied, this paragraph 21, that's stated in Porter and McGill, namely whether a fair-minded and informed observer, having considered the given facts, would conclude there was a real possibility that the tribunal was biased. A fair-minded and informed observer would have concluded there was a real possibility the court of first instance was biased for two main reasons. First, the Supreme Court was a complainant against me, both to the Attorney General and the Bar Standards Board. This is page 465 of the electronic bundle, the letter from the court to the Attorney General. And in fact, it's the last paragraph, page 15, 467 of the bundle. And it says in terms, in light of these events, Lord Reed has decided that the court should refer the matter to the Attorney General. And it then says, Lord Reed also intends to make a complaint about Mr. Crosland's conduct to the Bar Standards Board. So in the court's own words, Lord Reed is a complainant. And second, my defence involved an allegation that the Supreme Court had made itself complicit in the suppression of evidence, and in relation to that, just inherently difficult, with the best will in the world, for the court to be entirely impartial. And for both those reasons, the Supreme Court had, or could have been perceived to have, a vested interest in the outcome. I made those points in my application for the hearing to be live streamed.
Is this something to do with the number of justices in the Supreme Court? Or would you make the same point if a High Court judge took the view, hearing a trial, that contempt had been committed in front of him or her, but directed that the hearing of any contempt application should come before a different High Court judge, there being approximately 120 High Court judges?
My Lord, I think that is part of it, of course. As I understand it, there are just 12 justices of the Supreme Court. That might, the reality I can't speak to, but that might imply to the observer that that's quite a tight, close community and difficult for people to be fully independent of each other. This was the point in Lowell, that the prosecutor in that case had also been on the tribunal with the members of the tribunal in that case, and therefore there might be a perception of proximity between those people.
Thank you.
So yes.
Now, your first point, therefore, was the Supreme Court was a complainant.
Yes.
What's your next one?
And the second point was that my justification for doing what I did was that there had been concealment of Mr. Grayling's error in the judgment of the Supreme Court. As the Attorney General acknowledges, it's there in the Statement of Facts and Issues. The draft judgment omitted any reference to that error. It made no reference to the fact Mr. Grayling had used the 2-degree target, and it informed the public that, to the contrary, he'd taken the Paris Agreement into account when his own pleadings said that he hadn't because he thought it wasn't relevant. So
the original judgment.
This is the original, the Heathrow,
yes.
My lady, yes, the Heathrow appeal.
So what is it? So is your complaint that any hearing by the Supreme Court relating to the original judgment should have been by different members of the court?
So my lady's asking me what I think should have happened in practice, and this is a very unusual situation, and it's, hopefully not something that arises, very often. My submission had a proper analysis taken place, including around proportionality, including sort of the limited nature of the breach, and the concern around the independence of this court to deal with contempt of court. It might have made it more likely the decision of this court was to make a referral just to the Bar Standards Board, just to the Charity Commission, and say, well, here are two bodies who are properly independent, who can look at these matters with fresh eyes,
okay.
And the sanctions available to both of them are quite potentially severe. That would be sufficient.
Yep, understood. Now, Mr. Crosland, I think we've covered the bias point, but I can see the time. But you've got your cost submission. You still want to deal with.
Just so I understand the time constraint. We need to absolutely finish by 1. Is that the position?
We are. I think we all understand the constraint, which is we've set aside this morning to deal with the matter.
Yes.
And we would like you to finish. And we do need to give the Attorney General a fair time to reply, and you may want to have a few words to say in response.
Of course.
Don't forget. We do. Yeah, go ahead.
Are you saying this court should have remitted the matter to another court because of the bias which you've described? I mean, we're talking about implicit, not actual bias, but...
My submission, what ought to have happened, given the limited nature of the breach, I completely understand something had to happen. What the court should have done is referred it to the Bar Standards Board, referred it to the Charity Commission.
That's what you just said.
Sorry.
But should this court not have heard the application itself, but remitted it to another court to hear?
The application was made, wasn't it? The application was made by the Attorney General, so the court had to do something with it. Yes, if anything, it should have been remitted to another court. I mean, potentially, if there needed to be a trial, the trial on indictment historically had been used. Whether that might have been brought back into play in this instance is possible.
And are you aware, just very quickly, that there is a Strasbourg court case which considers summary proceedings for contempt, and which tribunal should hear the application?
I'm not, in fact, aware of that.
I can give you the reference, but it's Cipriani in Cyprus. I just wanted to know whether you'd had a chance to look at it. Maybe you will.
Thank you very much.
Application number 73797 of 1001. 73797.
Very much.
2001.
Turning now to the matter of costs. There's no fixed procedure for a contempt of court case before the Supreme Court. Specifically, the rules of the Supreme Court did not apply to a first instance hearing before the court. That was 2.1. The rules of the Supreme Court, these rules apply to civil and criminal appeals to the court and to appeals and references under the court's devolution jurisdiction. As was to become clear, neither the court below nor the Attorney General had given detailed consideration to what that meant in terms of the costs ahead of the hearing. The court had, however, given me a clear indication that the procedures applicable to criminal cases would be followed. Page 528 of the electronic bundle, 26th of March 2021, the court registrar sent me an email saying, as for live streaming, criminal trials are not live streamed. The justice has decided that this practice should be followed in this case. As for the procedure at the hearing, the sequential procedure will be as you have outlined. And the procedure I'd outlined was the procedure for a criminal case. So I wanted to understand what the procedure would be. And as a result, it was my understanding and expectation that any application on behalf of the applicant, the Attorney General for costs, would have been subject to the ordinary principles applicable to criminal proceedings.
Understood. Well, that's very clearly set out in your case.
And the leading judgment on this, which I hadn't looked at the time of my case,
right,
is RV Northallerton Magistrates Court, ex parte Dove, 752 of the electronic bundle. Again, I'm fortunate to be able to invoke Lord Bingham, who delivered the lead judgment. 757, he quotes Wally. This court takes the view that whenever a court is imposing a financial penalty or making an order in regard to costs, it must have regard to the means of the individual against whom the order is going to be made. That does not necessarily mean a very detailed examination of all his finances has to be entered into by the court. And it goes on to say, it would be quite wrong to impose a very small fine and a very heavy order for costs. The two must go in step. And Lord Bingham then quotes Lord Widgery in the case of Hayden. As a matter of principle, it would be wrong to penalise a man, that is to say, increase the punishment suffered by a man, merely because he had taken advantage of his constitutional right to a trial by jury. It is noteworthy in the present case that principle is explicitly recognised by the judge when he deals with the fine. And then Lord Bingham continues, in Firmston, the appellant, following a trial in the Crown Court, had been absolutely discharged but ordered to pay up to £400 of costs to the prosecutor. The Court of Appeal reduced the order for costs on the ground that it was out of step with the substantive penalty imposed.
Yeah. Now, this is the context is criminal proceedings generally, as I understand it.
Indeed.
Yes.
And my submission is that
Well,
I understood that that was the procedure to be followed in this unusual case.
We've got the point. I think I really must give the attorney time to respond. We have all your points about your financial means, and indeed, we are conscious that you would rather they were not ventilated in a public place anyway.
My Lord, thank you very much.
Thank you. Thank you very much indeed, Mr. Crosland. Yes. Mr. Adley.
Lord, may I begin with the jurisdiction point?
Yes.
In my submission, it would be right for this court to revisit that question. It was dealt with very briefly at the end of a long hearing before the court hearing the application. I don't know whether you've seen the transcript, but it occupies just 3 small pages at the end of the transcript. And there was only one copy of the relevant statute in court, which I had to hand up, and the 3 justices had to huddle over it. So it was not a fully argued point.
Mr. Adley, you can take it for granted that giving permission to appeal doesn't create a jurisdiction if there isn't one. So if you can persuade us that there generally isn't one, it's something we're going to have to take seriously, notwithstanding that there was permission to appeal.
I'm grateful. Well, that is what I seek to persuade the court. If there were such a right of appeal from the Supreme Court to the Supreme Court, that would be an extremely unusual state of affairs. And indeed, on the basis of our researches, it will be a unique state of affairs. There is no other situation that we are aware of where a court can hear an appeal against one of its own decisions made by judges of equal seniority. There are, of course, cases where certain courts have different levels of judges. So a master's decision in the High Court can be appealed to a High Court judge. A district judge's decision in the county court can be appealed to a circuit judge. But that is because there is a clear hierarchy within the court in the governing statutes. There are also in some tribunals procedures whereby a judge can set aside a decision of one of their colleagues, usually on the basis of error of law or obvious unfairness. And that case is then set aside and reheard. But that, again, is not an appeal and a determination of by a judge at the same level that the fellow judge's decision was wrong. So it would be a very strange state of affairs if it existed, and one would expect to see the clearest possible statutory language if that were indeed the intent of Parliament. There's only one candidate for the statutory basis for such an appeal, but it's Section 13 of the Administration of Justice Act 1960. That's at tab 11 in the second volume of the authorities, electronic page number 952. The court hearing the application seized on the words within Section 13.1 that says, an appeal shall lie under this section from any order or decision of a court in the exercise of jurisdiction to punish for contempt of court, and regarded that as an unlimited statement that whenever a court exercises its contempt jurisdiction, there shall always be an appeal.
Yes.
But that subsection begins subject to the provisions of this section, and it has to be read in the context of the subsections of that section. When one moves through that section, one comes next to Section 13.2 and 13.2a, which together set out what we would say is a comprehensive code of the destinations of appeals in contempt cases. So an inferior court to the High Court, the County Court to the Court of Appeal, a decision of the Crown Court to the Court of Appeal, and so on. If it were really the case that in the unusual circumstances where the Supreme Court itself hears a contempt application sitting as a case of court of first instance, that there is then an appeal from that to another constitution of the Supreme Court, one would expect that to be spelt out in this comprehensive list of destinations of appeals.
Conspicuous by its absence.
Yes. And another striking feature of Section 13(2) is that it covers second appeals in contempt cases, not just first. If you look at 13(2)(c), it's talking about an appeal from a decision of a single judge of the High Court on an appeal under this section, which says that it then goes to the Supreme Court. And that's significant because that implies that when the court hears an appeal in a contempt matter, that court then is also exercising its jurisdiction to punish for contempt of court. Now that means, if Mr. Crosland is right, that there's an appeal from this court, and infinitely, from every single further appeal. And that is an absurdity, we say. Looking on through this section, subsection 4 deals with appeals to the Supreme Court, and it incorporates by reference part of section 1 and section 2. We don't need to turn those up. That's putting in place the requirement for permission to appeal, but dispensing with the requirement for a point of law of general public importance, at least when it's a first appeal to the Supreme Court. But what I would draw attention to in both those subsections and subsection 4 is the repeated reference to the court below, being the court from which the appeal lies. And we say that's entirely inapt language to apply to a situation when one constitution of the Supreme Court is invited to look at the decision of another constitution of the Supreme Court. It's right to point out that in subsection 5 there's an expansive definition of court, but my submission is that taking this section read as a whole and in context, what it must mean is that there is an appeal up to the Supreme Court following the destinations set out in subsection 2, but in the unusual circumstances where the Supreme Court itself sits as a court of first instance hearing contempt application, that is the beginning and the end of it.
But you accept that subsection 5 includes the Supreme Court?
Oh, I do, certainly.
Yes.
But it's a case of reading the statute in context, and as my Lady Arden says, the conspicuous absence of any provisions to deal with how a Supreme Court should deal with the situation that arises here.
Can I just ask you this question, Sir Lee? Your starting point is it would be an unusual, and in fact you've not been able to find any example of an appeal to the same level of court. Is there any other example, if we followed your submission, of there being no appeal against a contempt decision? I mean, have your researchers shown any situation where there is a finding by a court of contempt and no right of appeal against that? No, for the very reason set out in section 13.2. There's always an answer in section 13.2 or 13.2a. So we end up with two extraordinary positions either way, don't we?
Well, we would say not, because what is required in Article 6 terms, that there's no right of appeal guaranteed by Article 6. What is required is a court that deals fairly with the issue that's before it. And if one happens to commit contempt of court in respect of the proceedings of the Supreme Court, you get a hearing in front of the Supreme Court, and that we say is entirely sufficient for Article 6 purposes.
Thank you. Yes.
I do recognise, of course, there is the Pinochet jurisdiction, if one can call it that, which is the court's inherent power to review one of its own decisions for procedural unfairness. But I refer you to the words of Lord Brown Wilkinson that Mr. Crosland read out. I'll give you the reference again. It's Electron and Bundle, page 773.
Yeah. I don't think you need to read it
I
out.
won't take
we
you
have
to it
read
again, but what it emphasises is that it's a very narrow power indeed, based on procedural irregularity. It is not an invitation or a power to revisit the substance of an appeal. And looking at the grounds that Mr. Crosland has pursued today, his main ground, his ground 1, is absolutely an attack on the substance of the decision. His ground 3 is a procedural matter about appearance of bias, a classic Pinochet issue, so you can at least consider that.
Ground 5 comes quite near procedural, doesn't it?
Well, we would say not. We would say that it's a.
Well, he says he got what he took to be an assurance from the court that criminal process would be adopted, and his main point is that he thought that applied to costs.
Well, if one were generous, one could analyse it like that.
Yeah.
We perceive it more as an attack on the substance of the court's cost decision, not a matter of procedural unfairness. He was heard on that matter of costs. Both parties were. They were given plenty of opportunities to make submissions. But if your lordship want to approach it like that, I won't stand in your way.
If we were to approach it in that way, what would be the next step for us to take?
Well, if you were to find that the case was tainted by procedural irregularity, it would be a matter of redeciding that case or that part of the case de novo. So if you were satisfied, for example, that there had been procedural unfairness on the costs point, but only the costs point, you could hear us both today from the beginning on the issue of costs. And
it would be appropriate for this constitution to carry out that exercise and to reach a decision de novo on that point. Is that your submission?
I would not suggest there could be any appearance of bias if this court were to go on and redecide a point de novo. I don't believe it would be necessary to assemble yet another constitution of the court to do that exercise.
We might have certain difficulties if it wasn't to include any of the justices who'd sat in any of the relevant
Yes, you're running out. Yes. So that's the.
I suppose the passage of time would cure all, Mr. Eardley, but wouldn't be very satisfactory to the parties.
Can I move now to the main focus of Mr. Crosland's submissions, unless I can insist any further on the jurisdiction point?
I think you can go on to ground 1.
It's notable that Mr. Crosland has put forward a different case today than the one that he identifies in his grounds. What he says today is that the court, on deciding that he was in contempt of court, ignored his motivations, intentions, and beliefs. That is not how it is put in the grounds, and it's not how it is put in the statement of facts and issues. What he says in the grounds is that the court ignored, quotes, the factual context, by which he means that it refused to engage with his contention that the court dealing with the Heathrow appeal had got it wrong, and dangerously wrong, in his words, being complicit in the suppression of evidence from the public. Not that he believed that, but that was the case. That is what he wanted to ask the court to look at. And his complaint in this appeal, if you look at his grounds and the statement of facts and issues, is that the court didn't do that. Just to read you how it's put in the agreed statements of facts and issues, the question on issue 1 is, should the court below have given specific consideration to the appellant's principal line of defence, which is that he acted as he did because evidence was being concealed from the public concerning the relationship between the proposed expansion of Heathrow Airport and the Paris Agreement temperature goal. Was being concealed, not that he genuinely and conscientiously believed it was being concealed. So there's a change in position. But let me deal head on with the case that he's presented to you today, which is that the court ignored his motivations, intentions, and beliefs. What the court did, and you'll have read the judgment, is that it looked at the issue of liability for contempt first of all, from a pure English common law point of view, and it accepted that there were three things that we had to show to the criminal standard. That there had been a breach of the embargo, that it had been done in knowledge of the embargo, and that that amounted to a serious interference with the administration of justice. It found all those things proven, and it did indeed say, looking at it through the common law perspective, that matters of motivation, intention, and belief were irrelevant to that. But what the court then went on to do was to apply a cross-check and look at it through the Article 10 lens. And that is what it does, starting at paragraph 39 of the judgment, where it deals first of all with Section 12 of the Human Rights Act. And it says in terms, we have also given consideration to whether a finding of criminal contempt in this case is compatible with Article 10. And it then goes on to apply the proportionality balancing exercise that it's required to do. And I'll come back and say more about what it was required to do under that exercise. But it is unreal, in my submission, to consider that as part of that exercise, the court did not take into account that Mr. Crosland's motivations, intentions, and beliefs. The whole hearing was imbued with his statements of intention and belief, as is this judgment, and it's expressly dealt with when the court comes on to dealing with the proportionality of penalty and costs. So if you move on to paragraph 47 in the judgment, for example, it says in terms, the respondent was motivated by his concerns and fears relating to the consequences of global warming and his disagreement with the decision of the Supreme Court. And
I think Mr. Crosland would say that at the liability stage, if you read 39 to 41, the focus is quite sharply on whether the embargo itself was justified, treating Article 10 as effectively satisfied if it was.
Yes, well, you need to read the judgment as a whole,
Yes.
And in the passage I've just read out from paragraph 39, the question that the court is posing itself there is whether a finding of criminal contempt in this case is compatible. And so we say it's really a distinction without a difference. It's right, it talks about the proportionality of the embargo at paragraph 41, no doubt about that. But this isn't a case where one could have a proportionate embargo, but it would be disproportionate to punish Mr. Crosland for a deliberate and defiant breach of that embargo, when the embargo itself said that breaching this may be a contempt of court. So we say that's
But that's perhaps a thrust of the question that I asked Mr. Crosland. The embargo applies to every judgment.
Yes.
And every provision of the judgment to somebody else, whoever it is, maybe the press, maybe somebody else, will be a breach of the embargo. But Mr. Crosland isn't saying that one must always carry out the Article 10 proportionality exercise, or if you do always have to, then in the vast majority of cases where you're just dealing with a disgruntled litigant, it will be satisfied. But what he's saying is that there is this extra step in a case such as his, and that paragraph 33 indicates that the court, the panel didn't recognise that step, which has become clearer since Ziegler, which I think was handed down after the contempt judgment.
Yes, well, paragraph 33 is still on the common law. Then it switches to Article 10 after that in the judgment. And I understand Mr. Crosland to be saying that Article 10 is always engaged, but there will rarely be a breach of Article 10 by upholding an embargo. But in his particular case, because of the strength of his convictions, it does amount to a breach. And although that's not expressly addressed in terms in the judgment at paragraph 41, my submission is that it's plainly in the court's mind because it's brought up in the passage I've just shown you at paragraph 47, for example, that this was a conscientious objection. And the court's view is that on the proportionality balancing exercise, it makes no difference because this is a short-lived embargo and it didn't prevent him saying anything but which he couldn't have said freely in compliance with the embargo 22 hours later. Mr. Crosland's response to that is, well, people might not have listened to me unless I'd engineered this publicity stunt and been seen to be defying the court. Well, in my submission, that is unreal for a number of reasons. First of all, there's a principal reason. Article 10 is about the freedom to impart information and ideas. It's not about a right to be listened to or heeded. And we do accept that the imposition of the finding of contempt is a prima facie interference with Article 10, but it certainly doesn't go to the heart of that right. It's a marginal interference, and it was simply to delay Mr. Crosland saying what he wanted to say about the judgment. But secondly, it's unreal, we say, to suggest that his concerns about this judgment would have gone unnoticed if he'd waited until the next day. I put to him in cross-examination that his organisation, Plan the Earth, is a modern campaigning organisation and a media-savvy one that knows how to get its message across. Well, he feigned modesty at that, but he didn't deny it. It's a charity with a website. It's a charity with a Twitter account that had 3,500 followers at the time, including Extinction Rebellion, which had 55,500 followers at the time. He has no difficulty in explaining and drawing attention to the decision of this court, and the decisions of this court do not slip unnoticed into the night. They are debated by academics, by politicians, by the media at large. It's unreal to suggest that a decision such as this about the Heathrow expansion case would have gone unnoticed. And the only concrete thing he points to now is the letter of Sir David King and other environmental advisors, which he says would not have happened if he hadn't broken the injunction. And again, we say that that is unreal. It is perhaps worth just turning up that letter. You can find it in full at electronic page 529, tab 17 in the appendix. It's a letter written to Lord Reed, the President of this court. First thing to note is the date, March the 30th, 2021, so a number of months after the decision and after Mr. Crosland's breach of the embargo. It's written in the run-up to the hearing of these contempt proceedings, and as we'll see, it's in effect a plea in mitigation for Mr. Crosland. It says we write concerning the Supreme Court's decision last December, and it makes a number of criticisms of that decision, along the same lines that Mr. Crosland has made. What it doesn't say is we only found out about this because of Mr. Crosland's breach of the embargo. And you'll note that it's replete with footnotes which are to Supreme Court cases. And then over the page, electronic page 530, all it says about Mr. Crosland, this is 2 paragraphs up from the end, is we understand why Tim Crosland felt it necessary to raise the alarm about the goals of the Paris Agreement being ignored by the British courts. Then last paragraph, the plea in mitigation, we urge the court to take appropriate steps to mitigate the profound harm its judgment has caused and to consider the actions of Tim Crosland in this light. So this simply doesn't support his contention that if he hadn't breached the embargo, Sir David King and the other 100 signatories of this letter would have been unaware of the court's decision. So there's a principled objection and a factual objection to his case as to why it mattered. Perhaps I should say a little bit more about the Ziegler case that's been heavily relied upon. It doesn't actually decide anything new about proportionality, we say. It's the big point in Ziegler was how does an appeal court deal with a lower court's decision on proportionality when it comes to it by way of case stated under the Magistrates' Court Act, which is a confined ground of appeal, scope of appeal rather. What it says about the substance of proportionality exercise, we would say, is entirely orthodox, which is that one must take into account and balance all relevant factors. And you'll see the reference to relevant factors and an observation that not all factors are always relevant in paragraph 71 of that judgment. And as I've said, reading the judgment as a whole, Mr. Crosland's motives and beliefs were taken into account to the limited extent that they deserved as relevant factors at the Article 10 balancing exercise stage in respect of liability. But what was not taken into account, and deliberately so by the court, was the correctness of its own judgment in the Heathrow appeal case. And of course, that was the focus of Mr. Crosland's grounds of appeal until he stood up and put it differently today. The court was right to not engage with Mr. Crosland on the substance of the Heathrow appeal case. And that is because, whether that case was rightly decided or wrongly decided, the operation of the embargo did not affect Mr. Crosland's ability to publicise his disagreement with it, except to the small extent that he had to wait for a week, having seen the first draft of the judgment, before he could do so. And I've just taken you through his case on why he says it impacted his ability to publicise, and I've explained why that case is wrong. And the court explained its approach to that matter in paragraphs 34 for its judgment.
Page.
This is electronic page 138. Because in the court's view, there was simply no rational connection between the breach of the embargo and Mr. Crosland's ability to pursue his conscientious aims of preventing what he sees as catastrophic results arising from this judgment. The reference, the words "no rational connection" appear in paragraph 35. That is the court's conclusion, and the right one, we say. And that being so, it simply can't come into the proportionality balancing exercise. But Mr. Crosland says, because my concerns about this judgment were well-founded and the implications were so great, that adds to the weight of my rights in the proportionality balancing exercise. My Article 10 rights are stronger because of that. But if there's no rational connection, as the court rightly says, between the operation of the embargo and his ability to publicise those concerns, it doesn't matter whether he's right or wrong. They don't change the weight to be attached to his Article 10 rights. And there's even a more fundamental objection to the approach he invites you to take, and it arises from the statement of the approach given by Lord Neuberger in the Samaid case, which is in the authorities bundle. This is one of the cases that Mr. Crosland himself relies upon. In my submission, it supports the position that I'm advocating. This is tab 3 in the authorities bundle. As Mr. Crosland explained, this was the Occupy protest where a number of tents were erected in the grounds of St. Paul's churchyard a few years ago, and there was an injunction application to clear the tents away. Can I ask you to look, please, at paragraph 40, which is electronic page 734. This is Lord Neuberger citing what Mr. Justice Lindblom, the judge at first instance, had said. Lord Neuberger says, the defendants argue that the importance of the issues with which the Occupy movement is concerned is also of considerable relevance. That raises a potentially controversial point, because as the judge said, it's not for the court to venture views of its own on the substance of the protest itself, or to gauge how effective it has been in bringing the protesters' views to the fore. The Convention rights in play are neither strengthened nor weakened by a subjective response to the aims of the protest itself, or by the level of the support it seems to command. The court cannot, indeed must not, attempt to adjudicate on the merits of the protest. To do that would go against the very spirit of Article 10 and 11 of the Convention. The right to protest is the right to protest right or wrong, misguidedly or obviously correctly, for morally dubious aims or for aims that are wholly virtuous. And then there's a slight gloss to that from Master of the Rolls. He says, having said that, we accept it can be appropriate to take into account the general character of the views, whose expression the Convention is being invoked to protect. And then at the end of paragraph 41, any further analysis of those views and issues would have been unhelpful, indeed inappropriate. And we say that's equally applicable here. It would be inappropriate and wrong for the court hearing the committal application to revisit and form a view on Mr. Crosland's submissions that the Heathrow decision appeal was wrong, because that's not what Article 10 is about. Obviously, it can take into account the fact that Mr. Crosland is concerned with important matters of climate change and so on. That's the gloss that the Master of the Rolls puts on it, but no further than that. It's not an opportunity, and it's not appropriate to review the merits of the original Heathrow decision. And indeed, it's not competent. A court is not competent to review the final decision of another court. And that's another reason why there are limits on what is relevant in the Article 10 balancing exercise in this context. I think the last point I need to make on ground one is this, and perhaps this is something of an answer to the point that my Lady Rose has raised. And it's what Mr. Crosland says about the structure of the exercise. He's looked at Ziegler, and he said that in determining whether there's a breach of the law or not, the Article 10 balancing exercise is part and parcel of that process. And he makes the point that this court went about the exercise differently. As I've shown you, it looked at the common law position, reached a view, and then did an Article 10 cross-check. The answer to that is the way the court went about it in this case was correct, because there's a material difference between the provision under examination in Ziegler and common law contempt, which was the subject here. Ziegler was an offence under the Highways Act, which in the statutory language said it shall be an offence to, I'm paraphrasing, disrupt the highway without lawful excuse. And lawful excuse begs the question, what is lawful? And we know from the case law that that requires consideration of Article 10 at that point, because if it's compliant with Article 10, it's not unlawful. So that's why in Ziegler there has to be, if you like, a part and parcel approach to the exercise. But I've told you the elements of common law contempt of court. They don't say unless with lawful excuse someone does X, Y, or Z. It says in terms it is a criminal contempt of court to breach a court order, knowing of the order if that breach is a serious interference with the administration of justice, and it's been confirmed by the House of Lords that there is no public interest defence. So this is not a Ziegler case where you have to bundle in an Article 10 consideration at the point of considering whether there's been contempt of court. It's a cross-check case.
But if you consider the main authority that they rely on in paragraph 33 of the judgment, which is Lord Morris of Borthey-Guest's speech,
yes,
in the distillers case, that was a case in which the court was considering, or the committee was considering, whether statements made in the press, articles in the press, had gone too far in urging distillers to improve its offer, and had thereby amounted to contempt given the pending litigation. And one can see that within that exercise of considering whether a contempt had been committed at all and whether the articles had gone too far, one has to carry out a balancing exercise. And if you decide they have gone too far and it was a contempt to publish those articles, then there's no real room to revisit that in deciding whether the contempt is justified. But this case is a different case, because within the question of the factual question of whether there's been a contempt, there's no proportionality exercise at all of an Article 10 kind. I just am concerned that taking that sentence in Lord Morris's speech, there's no such thing as a justifiable contempt, out of its context of the contempt that the kind of contempt they were considering in that case, and then using Article 10 only as a cross-check, or looking at it through the lens of Article 10, as you said, whether that is still the correct approach post-Ziegler.
Well, can I say three things to that? But first of all, we don't have the distiller's authority in the bundle, I'm afraid. I don't recall whether it's put as a balancing exercise in that case or not. But secondly, the evaluative element that your ladyship is referring to in that case is replicated in this case at the third stage of the requirement for criminal contempt of court, which is a serious interference with the administration of justice. And the court considered the seriousness of it by looking at the implications if people breach court orders when it suits them, and then it's simply a matter of the strength of their belief that leads them to do so. And the implications in other cases, if it catches on, where people with less conscientious motives than Mr. Crosland start breaching orders for more venal concerns, with the result that you have cases where breaches occur leading to insider trading, destruction of criminal property, removal of children from the jurisdiction, and so on. So that's the evaluative element that's brought in. It's not a black and white one. But the third thing I would say, that if, having done the cross-check, this court had come to the conclusion that, gosh, yes, we have been driven into a position where applying the common law as it stands, there's now a breach of Article 10, then this court will surely have taken the opportunity to revisit its formulation of the common law and to introduce some sort of qualified public interest defence. But it never got there in this case, because it was a plain and obvious case where the finding of contempt was entirely compatible with Article 10.
Oh, Mr. Idley, we better move on to the other grounds.
Yes, I can take those much more
Yes,
quickly.
I think so.
Ground 3 is the Article 6 point.
Well, maybe it's an Article 6 point. I'm not sure that it's not
or a common law perception of bias point.
mainly apparent bias point, isn't it?
Apparent bias point. But the position is that all courts have to grapple with the problem where a contempt is committed in their face or in relation to their proceedings, as to how to deal with that in a way that is fair and inspires public confidence. And there's been a general retreat from the summary approach to committal proceedings in almost all the cases and almost all the relevant pieces of either civil practice directions or criminal practice directions. Great caution is urged on any judges from immediately dealing with an issue of contempt, and the recommendation is always refer it to another judge who can deal with it. And we say that is exactly what happened in this case, and rightly so. Lord Reid referred it. Indeed, he didn't just refer it to a different panel of the Supreme Court, he referred it to the Attorney General to make an independent decision as to whether this merited contempt proceedings. The Attorney General acting in his constitutional role as the guardian of the public interest in the administration of justice. And that when that application was made, it went before a differently constituted panel. So we say that that was an exemplary approach to ensuring that the appearance of bias was avoided in this case, and it's the most that the court could do, because as we know from the Lonroe case, which is in the authorities bundle at tab 7, electronic page 810, only this court can deal with a contempt that is committed in relation to its own proceedings. It was suggested in the Lonroe case that matters should have been dealt with in the divisional court, and that was roundly rejected by the court that said, no, this is a case about contempt of the House of Lords, and it must be the House of Lords that deals with it. And the same must apply to the Supreme Court. Also rejected in that case was the suggestion of a trial on indictment, and that's since been confirmed in the Dallas case, that trial on indictment for contempt is obsolete. And it's said in terms of the Dallas case, neither the Attorney General nor the contemner has any right to seek a trial on indictment. So it had to be this court, and a procedure that gave a proper impression of a fair approach was devised and followed in this case. And we say, applying the test, which is would a fair-minded and reasonable observer, aware of all the facts, consider that there was a real risk of bias in this case? The answer must be no. Mr. Crosland's proposed alternative, which was simply to refer that he should have been referred to and dealt with by the Bar Standards Board and or the Charity Commission, would in fact amount to a complete surrender of the court's own right to regulate its own proceedings. The contempt of court would have gone unrecognised and unpunished and would be dealt with as a matter of charity law, as a matter of professional misconduct only. And that, we suggest, would be entirely inappropriate for the court to surrender power over the people who appear before it in that way.
Yes.
I've dealt with the details of Mr. Crosland's various points about appearance of bias in my written case. I don't propose to take up time on those. So perhaps I'll better move on now just to the final costs point.
Yes, and don't forget to give Mr. Crosland some few moments to reply.
Again, I can be very short on the cost point. I commend to you the court's judgment on costs, which is at tab 9 in the bundle. It's a comprehensive review of the principles of costs in contempt cases. It establishes costs normally follow the event in contempt. The usual question is what is the reasonable proportionate amount. The court may consider the defendant's means and the relationship between any fine and the costs. But the costs and the fine reviewed together must be proportionate in ECHR terms, and the fact that this is an act of conscientious civil disobedience is relevant on costs just as it is on penalty. And we say those are the right matters to look at. There is no basis for looking at the cost regime employed in the lower courts. Mr. Crosland refers to the Criminal Practice Direction, which it makes clear that it refers to the Court of Appeal and below, not to the Supreme Court. But in any event, we would say that it makes no real difference, because if that regime in the practice direction had been followed, once again, there are strong similarities between the approach in that practice direction and the approach taken by this court. The overriding rule is that the costs award must be just and reasonable. It's said that ordinarily there should be no great variance between a fine and the costs, but that's ordinarily, and the case that's being referred to there, it's not actually footnoted in the practice direction, but I think it's agreed it's the Northallerton Magistrates case, which is at electronic bundle 758, which says that there need not be any arithmetical relationship between the costs and the fine. And there's also in the bundle, there's an extract from Archibald, which expands on that a little bit. That's at tab 21 in the authorities bundle, electronic page 1173. And as well as citing Northallerton Magistrates, it also refers to a case in judicial review of a decision in Aylesbury Crown Court, where the defendant had been ordered to pay £400,000 costs in the Magistrates' Court, appealed to the Crown Court, ordered to pay an extra £200,000 costs for an offence where the maximum penalty was £150,000. And it simply goes to show that these are all matters of circumstances, and if justice demands it, there can be a wide variation between the appropriate costs and the fine that's been imposed.
Thank you.
So we say there's been no error of approach by this court. That means Mr. Crosland's case falls back to the usual basis on which costs are appealed, and of course the court will remind itself that costs are discretionary and that an appeal court shouldn't interfere unless the costs award exceeds the generous ambit within which reasonable disagreement is possible.
Thank you.
Unless I can assist any further, those are my submissions.
Thank you very much, Mr. Hurdley. Yes, Mr. Crosland.
I have a number of points.
Just before you start, I think Lady Arden raised one authority with you, which you noted down. We're obviously not going to expect you to respond to that now, but we would invite you to make any response about that authority, which you want to make. You don't have to make any if you don't want to, within 7 days.
I'm grateful.
Thank you.
So briefly, one procedural point, the costs of this hearing. Practice Direction 6 says that if a party wishes to defer making submissions as to costs until after judgment, the court must be informed no later than the close of oral argument.
Do you want to tell us that now?
I do.
Thank you.
That's that done. Mr. Eardley's point about conspicuous by its absence on jurisdiction, in my submission, that's simply Parliament not interfering with the unfettered jurisdiction of this court. It would be a difficult thing to say anything specific about it, because there might be various constraints given the size of this court on what is practically possible, as in the Lonroe case, for example. So there's good reason why that would not be included in the Act. My friend, Mr. Eardley, says I've changed my position between the last hearing and this, moving it from belief to fact. That is not correct.
I think he put it the other way around. He said you'd move from fact to belief.
Okay. In fact, before the court of first instance, I read my opening words. Just a quick reminder. It was, my lords, I broke the embargo on the Heathrow judgment because I believed that the evidence would breach. That was how I put it at the court below. If there's any semantic shift in my case, it's only because the Attorney General has now conceded in the statement of fact and issues that the government did use the 2-degree target, and also that reference to that was omitted by the Supreme Court judgment. So I took those facts as admitted facts. If there's been a change of position, it is from the Attorney General. He now says it's unreal to suggest the court below didn't consider my intentions, motives and beliefs on liability. Just to remind the court what he said in the court below, it is not necessary, we say, for the court to take into account Mr. Crosland's motives for acting as he did, or his beliefs led him to do so. So that was his position. In my submission, I don't need to deal with all the possible breaches of embargoes that are out there, which in many cases would properly be dealt with as contempt of court. The point in Ziegler is the court must look at the facts of the individual case. Mr. Eardley describes this as a publicity stunt. In my submission, getting the truth out there is not a publicity stunt. Holding public institutions to account when they get it wrong, when they make serious errors of fact, is not a publicity stunt. It is the right to freedom of expression that is the lifeblood of democracy, as so clearly set out by Lord Bingham in the case of Shaler. Mr. Eardley is flattering in describing Plan B as a modern media-savvy organisation. The reality is it is a tiny charity with one full-time employee. It is true we have a website. It is true we have a Twitter account. Many people do. Something less than 5,000 followers, that's maybe the number of people that attend a Darlington football match. On its own, that is not enough to get to counter what the government had told the public, that Heathrow expansion was consistent with international obligations on climate change. Mr. Eardley says there's no rational connection. There's no reason that letter from the experts couldn't have been written without the breach. If we go to that letter, page tab 17 of the appendix. We've heard the content already, but go to page 531. Some signatories. Fahana Yamin, lawyer and advisor to the Republic of the Marshall Islands for the Paris negotiations. Antonia Oposa, environmental lawyer to the Philippines, Normandy Chair for Peace, Ombudsman for Future Generations. Sir David King, former UK Government Chief Scientific Advisor. Melinda Janke, Director, Justice Institute, Guyana. James Hansen, godfather of, well, it doesn't say that, he's in fact referred to as the godfather of climate science in the US, ex-NASA scientist. Ralph Regenvanu, leader of the opposition Vanuatu. If you look at this list goes on for pages and pages. There's Nigeria, Ghana, the Solomon Islands, Sudan, Mauritius. I don't know any of those people. They're not in my address book. Those people would not have understood what was at stake in this case. The UK government claiming to be a climate leader ahead of COP26. The reality being, when it comes to the crunch, a key infrastructure decision with impacts for generations, for decades, on this country's carbon emissions, it had used the wrong climate target, deemed the Paris Agreement not relevant. There's no way that that would have got out there. were it not for the press coverage in this country and internationally. There's no way these people would have found the time to engage with it in the ordinary course of events. These are all busy people.
I think Mr. Erdley's central point is 24 hours later, you would have had the same impact.
My submission is just not the reality. What gave me the impact was the breach of embargo, which got people's attention.
Well, that's just speculation on your behalf, isn't it, Mr. Crosland? That's pure speculation on your behalf.
Well, what Mr. Eardley has to say is that the same thing that happened would have happened even without that. What I have before me is evidence that people were engaged, that they did take up the point. I am no longer the lone voice on this error. And Mr. Eardley has to say all of this would have happened anyway. Even if you hadn't done it, people would have heard your message from your Twitter account because you have a website. And I say the nature of things, that's just not real. Concealment, which is the essence of Lord Bingham's comments, which is ignored by the court below. One point that not yet brought up, this is page 212 of the authorities bundle. So electronic bundle, page 1160. Disclosures qualifying for protection, 43BE, that the environment has been, is being, or is likely to be damaged, or F, that information tending to show any matter falling within any one of the preceding paragraphs has been, is being, or is likely to be deliberately concealed.
Mr. Crosland, your reply should be responsive to what Mr. Erdley has been saying. I don't think that was.
Just that this was not addressed by the court below. And finally, my ladies, my lords, it would be wrong in my submission to view the government's error in this case as, in some sense, exceptional or egregious, or although it was, I mean, it's an extraordinary thing to do, to use the wrong target at this moment when the whole world is talking about the climate crisis enveloping us. Because the reality is we are in this position because for decades governments have been ignoring and marginalising the scientific evidence and finding ways to reassure the public we can have our cake and eat it. We can carry on consuming more and emitting more and growing the economy more while staying within the boundaries that make the planet habitable. That is not true. It is a tragic error, a tragic mistake, and nothing is more vital than that citizens are able to exercise their rights to challenge that and to bring it to public attention because it is a matter of such extraordinary urgency. And so, in my submission, never has there been a more important illustration of the value of Article 10, individuals holding powerful public institutions to account.
Thank you.
Thank you very much.
Thank you very much indeed, Mr. Crosland. Mr.
May I just put one matter on the record? It's been suggested a number of times by Mr. Crosland that by agreeing the statement of facts and issues, the government has somehow conceded that there was an error in the court's judgment, or perhaps even conceded that it was an error itself. There's no such concession. The Attorney General is not competent to make such a concession, and paragraph 6 of the Statements of Fact and Issues is simply a recitation of what's in the judgment.
Thank you. Thank you. Well, we're grateful to Mr. Crosland for the economy and precision and force with which he's made his submissions, and to you, Mr. Erdley, and to your legal team. We will take time to consider our decision, which will not include the costs of today, and let you have it as soon as we can, and then we will, if necessary, invite submissions on costs, probably in writing.
Thank you very much.